Hi, this is Erica Marilyn. I'm the founder of Perfect Legal Video, and I'm very excited to have with us today attorney Nicole Reeves Lavallee. She is a family attorney out of Worcester, and she has her own law firm there. I'm always excited to talk with Nicole. Thank you so much for joining us today.
Thank you for having me, and hopefully we can learn something new.
Well, today we are going to discover things about discovery. So why don't we start off with, what is discovery?
Discovery is probably the one most important thing to do. It's something that everyone should do in a litigation, but people don't necessarily know what it looks like or what it is or how to go about it. So discovery is basically gathering intel, documentation, responses from the other party so that we can make our case. It's sometimes it's gathering it from our clients, sometimes it's gathering it from third parties, but we have to gather all of this intel so that we can use that and better leverage your case so that you can get the results that you're looking for.
What type of discovery is permitted when you are working on a family case?
There is the same type of discovery in all types of cases, so it's not specific to family law, but they're subpoenas. So I would subpoena maybe your employer or your spouse's employer. So I want all of your employment records, or I'll subpoena police reports or things of that nature. So I'm going to subpoena a third party and ask them to produce documentation for my benefit. There's depositions that may or may not go with the subpoena. So sometimes the deposition is going to be where I'm going to sit in a room with that person and I'm going to ask them questions under oath, and there's going to be a stenographer there that's going to type down everything that is said word for word, so both the questions and the answers. But if I'm asking it by way of a subpoena, then what I'm also doing is asking them to produce documents. So I'm kind of combining those two in one. The third option would be production of documents, which is exactly what it sounds like. I'm asking the other party or a third party to produce certain documentation. So for example, tax returns, bank statements, maybe some psychiatric reports or medical reports if there's issues with substance abuse, things of that nature, AA meetings, whatever the case may be. And then last is interrogatories, which are written questions that I'm asking of the other party under oath. So I'm asking you, can you please state in full, complete detail something. So for example, I'm going to ask you for full and complete details of each and every time that you've had parenting time with your child from January 1st of 2020 to present. And for each of those, I want you to state what you did with the child. How long was your parenting time? Who was present? So those are the types of questions that you would get. And obviously you can ask whatever you want, but that's just one example.
So I feel like some of the things you were talking about might need a little bit of a definition. We spoke about depositions just a couple times ago. I know we did grandparents' rights the last time, but what is a subpoena?
Sorry.
Okay. So what is a subpoena?
So a subpoena is a order that we're submitting to that third party. And so basically I'm going to subpoena the police department or a school, and I'm going to ask them, the exhibit sheet is going to have everything that I want them to produce. So for example, if it's school records of your child, I'm going to ask for the grades. I'm going to ask for any communications between the parents. I'm going to ask for any progress reports. I'm going to ask for any time the child has gone to see the nurse practitioner, whoever's at the school. I'm going to ask for guidance counselor records. I'm going to ask for attendance, including any tardies or absences or things of that nature. So and obviously if you have an IEP or something like that, we'll get more expansive. But I'm going to ask for all of those records to that one particular agency or company that's going to have those records. So same thing with your employer. If I'm subpoenaing the spouse's employer, I'm going to ask for your W-2s, your pay stubs, your, any hours worked, any bonuses, any health insurance costs, any 401k benefits or annuities or things of that nature. I'm going to ask if you get, any privileges such as company cars or paid lunches or paid vacations. So I'm going to ask for as much information as can possibly have from that one particular individual. And then they have to produce those records, or they have to tell me why they're not going to produce those records.
Wow, that's really interesting. Do people just ever flat out refuse to produce records without a good reason? And what happens then?
Great question. The answer is yes. A lot of times it will be something like the police department. So if I'm doing the City of Worcester Police Department, a lot of times they have to give notice to the other party. Maybe the police officer themselves, which is one of the parties, wants to object. And so you'll have that. Some other times we've had it where they said, oh, it's medical records, we're not sure you're entitled to that. So those are the people that are generally objecting. And what they do is they have to notify us. They have to say that they're going to object. If they do object, then as long as they put it in writing or some form that I'm not accepting of it, then I would have the right to go into court. But it's their burden to file a motion to quash. And a motion to quash is basically to stop it. It's a motion to stop the subpoena and stop the action itself. And so I would be opposing that. And then obviously whatever the judge rules on, maybe they would say, Nicole, you're not entitled to the last 10 years of those records, but only just the last 2. And then obviously the company that I'm subpoenaing would then have to comply and give me the last 2 years of records.
That's really interesting. Now, you and I have worked on things before, and over trying to do discovery with someone that doesn't want to provide records. And there's all kinds of tricks that they may play in order not to provide the records. I don't know if you'd like to, not from, from just in general, what you've seen over the years of the silly things that happen where people will do so that even though they know they have to provide it, they really try not to, and they have these tricks.
Well, I think the biggest issue is there are rules that have to be followed. So one of the rules is when you're responding, you as the respondent is supposed to answer the question. So if it's a production of document, you have to say, please state or please provide all of your 2018 tax returns, pay stubs, whatever the thing is. And then underneath it is supposed to be their response, which either says attached as exhibit A, for example, or C attached, or plaintiff only has 2017 tax returns and there are none, or something. They've got to articulate something so that me being the recipient can understand why documents were not provided. So that's the first thing that they're supposed to do. When you're dealing with a lot of pro ses, they won't have any clue to do that. And if I'm lucky, they'll write on my request for production of documents, none, or here it is, or something to that effect. So again, even something very simple, pro ses can do it, it can still be done. The problem is really when you have attorneys who know the rules, who are supposed to follow the rules, and they do one or two things. One, they put it in a CD, or they upload it to a portal. I'm having a lot of that now during COVID, that they're just extremely lazy. They get it from their clients, they don't bother to even look at it, and they literally just send it. So the problem with that is there's no uniformity, there's no information. I don't even know what I'm looking at half the time. I asked you for bank statements. Why am I getting tax returns? Why am I only getting 3 years of tax returns when I asked for 5 years? And so it makes you, as the attorney, scratch your head and go, what the frig are you people doing? And so now I've got to end up putting these puzzle pieces together that, one, I shouldn't have to do. 2, it's costing my client a boatload of money for me to sort out something that should be in an organized fashion. And 3, a lot of times the records are completely incomplete of what they actually did provide. So then I have to go back to them again and say, hey, you didn't comply with production of documents number 15, 17, and 23. I need to have them. And then we go back and forth as to whether or not they, A, say that they did it, B, they say that they don't even have it, or C, they just flat out ignore me. So from an attorney's perspective, most important thing to do, hardest to usually get.
I mean, that's interesting. I remember at one point you said it just looked like somebody threw the documents up in the air and they all fell in a pile. And you're like, I don't know. I don't know what any of this is. So, I mean, that's an interesting, it's definitely interesting, and it definitely prolongs the process, and it costs people on both sides a lot more in the long run, because eventually it'll catch up to them. So that's, that's really interesting. I guess they're just hoping that you give up.
And that's usually what it is. You know, in the game of 52 pickup, that's kind of what it is literally just throw it up in the air, see where it falls, and let them make sense of it. The problem is when I have to go into court on a motion to compel, I'm going to get attorney's fees. So while I end up having to do the legwork in the beginning, there's going to be consequences for that attorney and or that other party for doing that and having me to have to go and figure out what all this means.
So the other question, just to reiterate for anyone that didn't get to see your deposition interview that we did a couple weeks ago, if you could just define a deposition so that we know what you're talking about going forward.
So a deposition is something where I'm going to ask a person, usually a party, a particular set of questions. And unfortunately, it could be pretty much anything. So I'm going to ask them questions. It is going to be answered under oath. There's going to be a stenographer that is going to type and dictate every single question and answer. And then they're going to give me a transcript that I can use later for court. The big part of that is you are under oath, and I can use that later on at trial. A lot of times attorneys will kind of take you down a side road. One, because they want to see how you react to a question that is completely irrelevant, or two, they want to get you off your feet where now you feel like you're stumbling and so you don't know where they're going. So depositions prep work is extremely imperative. It's absolutely imperative to do. And depositions can last anywhere from 10 minutes just for informational purposes all the way up to 2 or 3 days. So it can be very extensive, but all of that information can be used against you if you go to trial in your case.
Now, in general, I mean, minus all the crazy games that we talked about earlier, like how long should discovery take?
So each discovery source will take you 30 days. So if I request a subpoena, or I request a deposition, or I request production of documents or interrogatories, each one of those gives the other party 30 days to respond. So they're going to have 30 days to respond. And then again, you have to look at it and determine whether or not it was a full response or a partial response to figure out if you have to go into court for a motion to compel. So each discovery process is 30 days. I would never recommend that you do all 4 of them at once. You want to start gathering intel. So sometimes I do the subpoenas first. Sometimes I do just the production of documents and interrogatories first. I'm always going to do the depositions last because I'm always going to have enough ammunition to gather all of the stuff to show them and say, hey, look at this document, look at this document. So I already know where I'm going with that. It's kind of like a mini trial, if you will, because I know where that information is going to take me and how I can best present it. So overall, discovery phases itself probably last anywhere from 6 months all the way up to a year on average. But again, each block of those times is going to be a 30-day window.
That makes a lot of sense. And I know they'll get in trouble if they're a lot later than that. I mean, with COVID, it's been a little interesting. Things have kind of taken longer. I mean, would you agree? Are they forgiving people for being late?
I don't think that they're forgiving people for being late. I think that the attorneys don't want to go through the hassle right now. So I'd rather beg and plead the other attorney to give it to me. And if that means I have to wait 60 or 90 days rather than me going into court, because for me to go into court, I have to file a specific motion that I would normally do. And then I have to file another motion to have the motion heard. And then I have to wait for the judge to decide whether or not they're even going to hear it. So it seems to be, I'm doing extra work on filings. I'm doing extra time and waiting for the hearing to even be scheduled. So, and in the meantime, chances are the other attorney is going to give me the records, and then I'm back at square one. So it's really one of those things that right now during COVID, we have to be cost effective and look at the big picture. Is it worth my time? And a lot of times it is not. But can I threaten it? Yes. Will I proceed with it? Really depends on the circumstances of the case and how much time I really have already given you.
So why is this so important? Why is this discovery important? What do you get out of having discovery done?
Well, I don't know anybody that can honestly say to me, I know everything. You don't know everything about your case. You don't know everything about the other party. So again, even if you're married to this person, even if you were the person that took care of all of the finances, great. But what about the other parts of that? What about, say, the child issues? If you think that person is lacking in great in financials, but lacking in just basic skills of parenting, well, that's where we're going to gauge those questions. That's where we're going to ask for discovery documents on those types of things. So there's nobody that's perfect in every area. And so when you're talking about a divorce, you have to look at 15 plus factors. Well, guess what? In order for us to look at those 15 factors, we need to examine all of those. So again, you might be perfect in one or two of them, but what about the other two? What about the 3 or 4 that you have no idea about? Those are the things that we're going to look at. So what we do is we hone on the things that we think, A, the other party is completely deficient at, or B, we have no clue because we weren't the financial person and we have no idea what assets there are. The best way for us to find out is to ask the person that was in charge of the finances. So it's a gathering mechanism. It's a way for us to learn what is going on with your particular case. Where are your deficiencies? Where do you excel? How can we best serve you? And what should you get as a result of all of this information that we've gathered? And the problem is people want to go, I just want answers. Great. I have a client right now who's sitting there going, but it's been 11 months. And I go, okay. And I told you, and the fee agreement says, plan on it being at least 2 years. And we had COVID during this time. So 11 months isn't unreasonable, but these are the things that people don't necessarily know, or they think that time frame should be much shorter. It's not. An average time for a divorce is going to be probably 2 years. Their tracking order says, yeah, we should probably conclude it within 14 months. That's highly unlikely in most divorce cases. Can it be done? Sure. But again, it needs to have that discovery component completed so that I can best advise you to say, this is what I think you should do, and this is what I think you should settle for. Without that, you're just a fish out of water and you have no clue. So why are you bothering to hire me then?
I mean, you don't want to guess. I mean, that's the bottom line. You absolutely don't want to guess. And the fact of the matter is, most of the time in a divorce case, you don't know everything that was going on. And I mean, I could ask you, like, how many times were people completely floored by what they found out?
Oh, more than I can count. More often than not, the only thing that I could say is only in mediation cases are people really on equal playing field and they actually know what's going on. Anybody that really kind of goes through the litigation process, there's always a spot that they're going, holy crap, this was my relationship, this was my life, I didn't know that. There's always some of that aspect, and I can't even tell you, like in all of my cases, I'd probably say it happens about 99% of the time. There's always one aspect that they just go, whoa. And that's the best way I can describe it.
How many times are they like 75% of it? Whoa.
I think that's probably a lower number, but probably 25% of the 75% go, whoa. So it's still a large number, unfortunately.
I think just keep your phones without the codes on them and make sure you know where your spouse is at night. What are the disadvantages, if any, to doing discovery?
I mean, the only real disadvantage is it's going to cost you money. But again, costing you money is also gaining you knowledge. So from my perspective, how do you say, oh, I don't want to spend the money. I don't care that I'm getting screwed. Okay, then again, why are you hiring me? Because you do have to spend some money. It's not an exorbitant amount of money, depending on the case, depending on the circumstances. You know, we could be a one and done with this discovery and not have to do a second and a third time. It all depends on the facts of your case, but you kind of have to make that effort, because if you don't, then again, you're just shooting yourself in the foot, and you're going, well, I got screwed. Well, you got screwed because you didn't want to either A, listen, or B, look at the documentation that was actually presented. So, you know, unfortunately, it's one of those things that you really need to do at least preliminary discovery in order for you to make an educated decision.
So yeah, that I think that you're absolutely right. And at this time, I just want to say to anyone that has any questions at all about a family court case, absolutely pick up the phone and call Nicole, because she and her team are just, just unbelievably diligent, intelligent. They've got fantastic strategies. They can work both sides of a case, and that's quite often how you can, get the best results, is to know what the other side is thinking. And it's just a true relief to the people that work with her to know that someone really does have their back, because so often when you go in for a family case, you are feeling completely defeated. You have no idea, like, your world has changed, maybe your children's worlds have changed, everything is different, and now you've got all this legal speak in legal situations to deal with, and you have no idea. You've never been through this before. I will tell you, Nicole treats her clients like family. She will sit you down and she will even say, don't be stupid. So, I mean, it's really encouraging to have someone like that on your side. So please pick up the phone and give her a call. I have one last question for you today. Is there any time frame when discovery is not permitted?
So that's usually determined by the court. So after your pretrial hearing or your status conference hearing, one or both of them, the judge is going to make a determination that says all discovery must be completed by X day. And X is usually, 30 days prior to trial or something of that nature. So that really means that you should have everything done, obviously, because how do you prepare for trial if you're still waiting for documentation a week before court? You're not being prepared. So they have to give you that time frame where cutoff date is whatever the court orders, and you have to have everything in by then. And you have to obviously exchange whatever you're going to be using for trial with the other party by then. So again, you need to know what that is. And that's when you're going to be precluded. Now, I've seen people that want to issue subpoenas to, one of the parties to testify at court and to bring with them. No, I'm not bringing anything with them. I'll bring my client to testify, but I'm not going to bring you documentation that you should have already asked for. So I would do a motion to exclude that portion of the subpoena.
Well, I have to say, that is very interesting, and it makes a lot of sense. I mean, people need time to review the documents before they have to go before the judge, and the judge needs time to review some of the documents so that she knows how to make the judgments, and has a little bit of an introduction to what's happening in the case before she hears the two sides. So, I mean, that definitely makes a lot of sense. Is there anything else you want to talk about today? And I get so excited about talking to you because you have the best stories. I mean, they're not the best at the time that they're happening to those people, but they're certainly interesting later on.
I think the biggest takeaway is, regardless of what we're doing, and I thank you for all the kind words, but I think at the end of the day, it's one of those things that, when you're sitting there and you're overwhelmed and you're in my office, guess what? You need to have that game plan. You need to have a strategy. That's why we do the discovery, because again, you don't know what you're supposed to be looking for. That's why you hire an attorney, so they can ask the relevant questions. They've already sat with you and they've already listened to your story where you're saying, well, I don't think he's done a great job at this, or he really works off the books. guess what? All of those things are tip offs to us so that we can ask the relevant questions. So while you're telling your story, we're taking copious notes to say, hey, we need to bring up this point in this discovery format, and we need to do this in this discovery format. So we're gathering that intel, and you don't necessarily even need to know it. It's just a matter of us knowing what we're listening for so that we can do our job to protect you. And you need to understand that that other person, they're going to continue to try to be a bully, because that's the best way that they know to get what they want at that moment. So while you're sitting there cringing, going, oh my God, how is this happening to me? They're going to take full advantage. If you have an attorney on your side, we're happy to tell them, go away. We're not going to play your game. And we're going to go through this procedural process before we make a decision, rather than jump and just do whatever it is you want to do.
That's right. And there's one thing I think we should mention is that you, while going through discovery, may actually see the need for an outside expert. So if there was a business involved, you might have an assessment on that business. You might have an assessment on a vacation home. There might be a lot of extra documentation that the person that comes into you didn't even think about, now needs to think about. And I mean, that could be a whole nother interview probably, talking about the types of experts that you work with to help gather enough information and to make your case so that your clients get a fair shake in the courtroom.
Everyone will always tell me that their inheritance is worth zero and their business is worth zero. It's amazing how they can run a business for 20 years and it's still worth zero. Guess what? Any of my experts will not tell me zero, because it's never worth zero.
Right. I mean, that just doesn't make sense. So it's nice to have that level head and that experience behind you, like I said before. And I just want to thank you so much, Nicole. I think that your information is super helpful for people that are considering this, and even with knowing that sometimes people consider divorce for years before they actually get one, because it takes a lot of guts, a lot of, getting your emotions underway, and having the courage to do it. So all this information really helps people prepare if they haven't already made that leap.
Absolutely.
So thank you so much for joining us. We'll look forward to seeing you next week.
Thank you.